I'm Bill Peterson, Minnesota estate planning attorney. When you die, and if your spouse remarries, will your spouse's new husband or wife and the stepchildren inherit your children's share of the family inheritance? Once upon a time, when mom or dad passed away, the surviving spouse lived for a few years with a family member or in a nursing home and then died. Today, the typical surviving spouse will live for another 20 years or more, often in good health, and will want to enjoy life, frequently meaning that they want to marry a new spouse. This often causes distress in the first family because the children may feel that the surviving spouse has let down the memory of the deceased mom or dad. What's more, the first family may have conflicts with the new spouse over the care of mom or dad and the use of the surviving spouse's assets. If the new spouse also has children from a previous marriage, the first family may resent the influence that the stepchildren exercise over their parent. Now, the Brady Bunch makes good TV entertainment, but very few blended families work out with the harmony of that sitcom. Now, some people will say, my spouse would never remarry and leave my assets to their spouse's children. But think about that. You married your spouse because of that person's attractiveness, personality, and intelligence. Don't you think that after your passing, another possible mate won't see your spouse's personal charms? Add to that the assets that he or she has from your estate, and you have a perfect situation for a new matchmaking. And what about the new spouse? Don't you think that he or she will want access to your surviving spouse's wealth and then to pass it on to their own family? Now, this is what we call the lateral transfer of wealth, and it is the source of huge conflicts in our society and in the courts today. Do you remember when Anna Nicole Smith married oilman J. Howard Marshall? He was 89 years old, and she was 28 years old when they married in 1995. Now, he lived for another 13 months. Anna Nicole then inherited Marshall's huge fortune, much to the anger of Howard Marshall's children from his previous marriage. However, there was very little that they could do, since Anna Nicole was his wife, and his estate plan had not anticipated Howard succumbing to Anna Nicole's charms. Was Anna Nicole a predatory gold digger? We'll leave that for you to decide. The probate battle has gone up and back from the U.S. Supreme Court. Right now it appears that the Marshall fortune will probably go to Smith's 1-year-old out-of-wedlock daughter, Dan Lynn Burkhead. Stay tuned when more dish comes out. What the Anna Nicole Smith-Marshall case illustrates is that family estate planning should anticipate second marriages, whether due to the death of a spouse or a divorce. The estate plan should envision what should happen to the surviving spouse's legacy as well as to the children's share upon remarriage. The only reasonably sure way to control this is through a trust that continues to monitor the family developments. Even a well-drafted will cannot deal with these changes in circumstance. I'm Bill Peterson, Minnesota estate planning attorney. Call me at 952-921-5818. Let's talk about your estate plan.